All right, good afternoon. My name is Yao Nkansa Bankro, the founder at Superlogy and Superlogy Studios. I'm also a lawyer. I set this up primarily to engage, to educate, and to empower on matters pertaining to the law. So some of our initiatives have included classes for students, law students, videos explaining case law online. You can follow us on our socials. Over the course of the past year or so, we've seen a wealth of decisions emanating from the Supreme Court of Ghana touching on marriage. And when we put out some of the videos, the question that arose was what's the overall effect of these cases? And indeed, what is the overall effect on the institution of marriage and whether marriage is still worth it? So we have today a very distinguished jurist who has acceded to our request to throw light on this topic for us. He is a product of the University of Ghana and Fordham University in New York, USA. Indeed, he is a sitting justice of the Court of Appeal, and he's the author of two very highly acclaimed books. I have my copies here, very autographed copies. The first is the Contemporary and Evolving Issues in Civil Procedure, and the second is Essential Themes in Land Law. These are books that indeed any practitioner will find incredibly useful. I recommend them. My Lord, I will yield the floor to you now to proceed. The structure is for a 1.5-hour session and then 30 minutes of questions. Thank you so much. My Lord, the floor is yours.
Thank you, Yao. My name is Justice Alexander Osei Tutu, as I have been introduced. And this afternoon, I'm taking you to the matrimonial realms. So we'll be looking at a very significant issue that borders on our social and religious and moral life, and that is marriage. So the topic is marriage still worth it? Is marriage still worth it? So today we are considering the judicial perspective. And next slide. As an overview, we will be looking at two main parts. The first part, you will consider some misconceptions about marriage. We also look at marriage itself, what it means, and the various types of marriages in Ghana. Then we look at how marriage was perceived in the past and how it is perceived in modern times. So the traditional and modern notions of marriage. We will then consider implied and constructive marriages and registration of customary marriages and Mohammedan marriages. How does it operate in Ghana? And for part two, we will consider property distribution and settlement upon divorce. And the question most people are asking is whether marriage is an investment. So you look at that. And we also treat the law, love, and property, and factors that are normally taken into consideration by the court when it comes to property distribution. And you look at the way forward and conclusion. Next slide. So the fundamental hypothesis. We all have to understand that the law does not create love. It rather seeks to protect it. There was this particular case by the Supreme Court that I deem it necessary to bring to your attention. And it has to do with Patience Atta and Atta Moses, our own former Black Stars player, Atta Moses, which was decided in 2013, where the Supreme Court, speaking through His Lordship Dr. Dateban, JSC, doubted whether the famous quote of the Roman poet Virgil in the Eclogues that love conquers all things is actually the case. The learned judge said, and I quote, "Alas, the empirical evidence from divorce litigation belies the assertion. It is one of the responsibilities of the court to sort out the messy consequences of love stories that have unraveled. This case falls within the category of love stories gone sour," unquote. So if you say love conquers all things, and sometimes you look at the cases that are before the court, you begin to ask yourself whether it is actually the case. But whatever it is, we believe that marriage is still worth it when it comes to the law, because it remains the most comprehensive framework for ordering property and children. The question really isn't whether the law values marriage. It is whether we still value what the law was built to protect. Next slide. So for my introduction, I say anybody can just go to any family division court in Ghana on a Monday morning. And when you see the court list, you will be overwhelmed to see the number of cases involving people fighting to exit their marriage relationship. Something they beg everybody, they beg the world to allow them to enter. So this evening, I asked myself, is marriage still good? If it is good, why do we end it in the courtroom? And if it is bad, why do we still continue to queue at the Registrar General's office to start it in the first place? Why is it that on Sundays, when wedding ceremonies are announced, everybody gets excited? Today, we are not asking whether marriage is lawful or not. We all know it is lawful. What we are asking is marriage still worth it? And what are the law? Not what your pastor tells you, not what your books tell you, your poets, your favorite poets, not what they tell you. We are talking about what the law actually says. Next slide. So for part one, we begin with some common misconceptions about marriage. There are some myths that people have about marriage, and today we tend to clarify all these misconceptions. The first is that customary law marriage is inferior to ordinance marriage. Many people think that ordinance marriage is ahead of customary law marriage. And this creates some sort of insecurity for those who enter into customary law marriages. And that eventually leads to dual marriage, because they get the impression that if they do not contract ordinance marriage, their marriage will be inferior. But what I want to tell you today is that both marriages are valid in their unique ways. The second misconception is that only a woman married under the ordinance can be called Mrs. There is no law in this country which says that if you marry under the ordinance, you must be called Mrs. and vice versa. It is a matter of choice. So even if you are married under customary law and you still want to be called Mrs., you can do so. The third misconception is that adultery is a ground for divorce for all types of marriages in Ghana. This is fallacious. Yes, adultery is a ground for dissolution under the ordinance. And this is provided for under Section 2.1 of the Matrimonial Causes Act 1971, Act 367. But since customary law is potentially polygamous, pretty soon we'll be looking at that. Extramarital relationship of a man does not constitute adultery as a ground for divorce. And this, the lawyers watching me may want to look at the case of Gifty Owusu and Sam versus Collins Dazi, which was decided in 2017. The fourth misconception is that in an ordinance marriage, adultery is a ground for divorce at all times. This is a misconception. If you look at Section 3B of the Matrimonial Causes Act, it says that after the adultery, if for 6 months the other spouse find it difficult to forgive and want to step out of the relationship, the law would permit him or her. But if he is able to forgive and they stay together, let's say after 5-10 years, the law would not permit the person, the other spouse to go to court on that ground of adultery. So after adultery, when it comes to the attention of the other spouse, and there was attempt to resolve it and it does not succeed, the law fixes 6 months, within which the petition should be filed in court. The next misconception has to do with the fact that customary marriage is considered to be a condition precedent to ordinance marriage. That before you can contract an ordinance marriage, you must go through customary law. Like I indicated earlier, each of the marriages are unique in their own way. So one is not a condition precedent to the other. Next slide. Also, there is this view that judicial separation is part of our laws. Yes, before 1971 or until 1971, Ghana was using the English Matrimonial Causes Act. So up to 1971, a person could go to court for judicial separation. But in 1971, when the Matrimonial Causes Act was enacted, no provision was made for judicial separation. So it's either you stay in your marriage or you go for divorce. You cannot stand midway that, let us separate, let's go to the court for an order so that we can separate for some time. And if it works out, we come together. This is not part of Ghana law. Our laws do not permit judicial separation. And for the lawyers, you may want to look at Knudsen versus Knudsen, 1976, 1 Ghana Law Report, page 204. The next misconception has to do with sharing of property upon divorce. The general notion is that upon divorce is 50-50. This is incorrect. Also, there's this misconception that only a man owes responsibility to maintain the spouse, make financial provision for them pending suit, or provide their property to them upon divorce. If you read the Matrimonial Causes Act from section 16 to 24, you realize that now it is not only the man who has to maintain the wife or the spouse. If the circumstances of the man are such that he is at a disadvantaged position and the woman is on top or relatively better than the man in terms of finances, the law enjoins the woman to also maintain the wife. And indeed, if that is not being done, the man can go to court for an order that the wife maintains him. In the same vein, when it gets to divorce, the court can look at the factors and ask the woman to push the man off in terms of alimony. Another perception is that where a marriage is found to be void, no property rights accrues. The law generally is that where there is a void transaction, yes, no title passes. But when it comes to marriage, the marriage can be void, all right, but the court can still make orders for one party to benefit or for property to be distributed, just like a marriage that was valid. And for this, the lawyers may look at the case of Teresa Owuo versus Francis Owuo, which was decided in 2017. Also, there's this misconception that upon divorce, each partner is automatically entitled to his or her individual property. This is a fallacy. The court can order one party to convey his own property, which the other party does not have any interest in, to the other party. For this, you can look at Section 21 of the Matrimonial Causes Act. Again, people think or perceive that in Ghana, prenuptial agreement is inapplicable. Today, I'm here to tell you that prenuptial agreement is valid in Ghana or is enforceable in Ghana. Last but not the least is that they say if a woman commits adultery leading to the divorce, she is not entitled to a share of the matrimonial property. This is fallacy. When it comes to property distribution, that is purely economic. It is distinguished from the cause of the divorce. So a woman can be guilty of adultery, but if she deserves to be given some properties, the court will still proceed to make the order. Next slide. Understanding marriage. Marriage is not a recent creation, enduring pillars of human society. It has shaped families, regulated relationships, and provided a framework for social order. Its definition, however, differs in many respects. And on this, I would like to refer to the definition given by Lord Penzance, when he said marriage is a voluntary union for life of one man and one woman to the exclusion of all others. A voluntary union for life of one man and one woman to the exclusion of all others. This may encapsulate the concept of ordinance marriage, but not the other types of marriage that we have in Ghana. Then, what are these types of marriages that we have in Ghana? Next slide. Ordinance marriage is the first. Let me pause here and say that so far as in Ghana now, if you buy any law textbook, what you read is that there are three types of marriages: ordinance marriage, customary marriage, and Mohammedan marriage. But I'm sorry to tell you that I don't think we still have ordinance marriage. We don't have ordinance marriage. And pretty soon, I will tell you why. But what we perceive as ordinance marriage, as defined by Lord Penzance, that it is a voluntary union for life. So it means that the two parties must enter into it voluntarily. It should not be entered as a result of compulsion. And it is a union for life. And it must be between one man and one woman, to the exclusion of all others. To the exclusion of all others. And this connotes the idea of monogamy. The second type of marriage that we have is the ordinance marriage. And according to the authorities, there are 4 elements for the ordinance marriage. The first is that, for the customary marriage, the first is that there must be an agreement between the man and the woman that they would want to live together as husband and wife. The second is that the consent of the man's family that they would want the woman as wife must be sought. The third is the consent of the woman's family that she should be married to the man. And the last but not least is the consummation of the marriage. That is the first sexual intercourse and living together in the eyes of the world as husband and wife. Meaning that if the parties marry and there's no sexual intercourse, that marriage will be deemed not to have been consummated. And for that matter, it may not be valid. And these elements were given by one Ghanaian famous judge by name Olenu in the case of Yaote versus Quay in 1961 decision, and it was repeated in the case of Rikebiat by Clara Sakite, 1962. So for that reason, in 1975, there was a case between one Boache and Bedu, where the man was cohabiting with a woman and he sent drinks to the woman's family. But when the matter ended in court, the court held that that drink that was sent was merely knocking ceremony, which we call akotuejan, and not the marriage, because it was deemed to be sent to knock the door, and that at the appropriate time, the man's family would come forward to perform the necessary rites. So because the ceremony was not held, it was deemed not to be valid marriage, but rather concubinage, marriage, Mohammedan marriage. Pretty soon, I will throw more light on that. Next slide. All right, what about church weddings? Are they valid marriage? It is acceptable if it conforms to the provision of the law. The law sets out some requirements or threshold. And if those requirements are met, then church wedding can still be or will be recognized as valid. And among such provisions are the fact that the place where the ceremony will take place, that is, that building must be registered for the purpose of marriage, and it must be administered by a qualified minister under the law. What about engagements? Normally in this country, when we talk about engagement, we are talking about customary marriages. So they are valid. Customary marriages are valid. So the concept of engagement or the terminology engagement is misplaced. What about marriage of convenience? Marriage of convenience is not acceptable in Ghana. We also have what we call common law marriages. That is where a man and woman are living together as husband and wife, but they consider themselves as married, but are not registered under the law. This type of marriage is not applicable directly in Ghana. There is also what we call civil marriages. Civil marriages is common in some jurisdictions. Basically, they have to do with statutory marriages where it is registered under the law. So if you want an example like that in Ghana, we can refer to the ordinance marriage as an example of civil marriage. Next slide. What are the traditional notions of the various marriages? The first, ordinance marriage. As for ordinance, I said from my perspective, I don't think we have an ordinance marriage. But for now, what we call ordinance marriage, the first element is that it is purely monogamous. Monogamous means one man, one wife. There's no opportunity for the man to go in for other suitors or other wives. It's also a contract. Normally, with ordinance marriage, it is more or less a contract between the two parties. Unlike customary law, which usually is between two families. And the next point you need to know about the ordinance is that it is not valid until it has been registered. All ordinance marriages must be registered under the law. The next type of marriage, which is customary marriage, is potentially polygamous, meaning that I did not say it is polygamous. I said it is potentially, meaning that the man can go in for other wives, other women. So it is not one man, one wife, as we saw in the case of the ordinance. And it varies from community to community. Customary law depends on the locality. So we need to understand it in that context. And it reflects the traditional values and cultural norms of the people. And one distinguished characteristic of customary marriage is that proxy marriage is permitted under the law. That is where, let's say, the man is domiciled in Europe. He can allow somebody to marry on his behalf. And when we are talking about the elements of marriage, customary marriage, I said that it must be consummated. But with customary marriage, if the man is not available and the woman was married through proxy, then it becomes valid immediately the ceremony is over, even without consummation. So let's take note of that. And this, you can look at the case of Sowa versus Sowa. The third type of marriage is the Mohammedan marriage. This is also polygamous in nature. The man can marry up to 4 wives. And it requires adherence to specific religious and legal conditions. Next slide. The modern marriage, ordinance marriage, which is, I did say earlier that it is registered under the applicable law, but in modern times, in fact, the ordinance marriage was introduced to us by the British, the colonial masters. But we all know in modern times, it is being threatened by LGBT plus, because originally what was sold to us as Ghanaian was that marriage must involve a man, only a man and a woman. But we all know in modern times, in some jurisdictions, same-sex marriages are permitted. And so I said this is threatened by LGBT. We also have customary law. And one thing about customary law marriage is that it is very flexible. And Mohammedan marriage, it is registered. It also needs to be registered under the law. But it appears that this particular law is outdated. So in modern times, we may say that we have these three types of marriages: ordinance, customary law marriage, and Mohammedan marriage. And is the term ordinance marriage now not a misnomer? I indicated that I have issue with ordinance marriage as it's used now. Why am I saying that? Ordinance marriage derives its name from the Marriage Ordinance Act, Cap 127, which created it. So when it was created as the marriage ordinance. But now the name has changed. If you can see what I'm holding, it is now called Marriages Act. Marriages Act of 1884 to 1985. So Marriages Act instead of Marriage Ordinance. In the past, it was in order that the statute was called ordinance marriage because customary marriage, which was its other rival, was oral and not regulated specifically by any statute. Customary law was defined and shaped generally by the court. So in the past, when we talk about Cap 127, it was referring to the marriage ordinance, That's why people could shorten it as are married under the ordinance or under Cap 127. But as we speak now, Cap 127, which was exclusive to ordinance marriage, has now ceased. So Ghana now, we don't have anything like ordinance, marriage ordinance. We have Marriage Act. And that Marriage Act is now Cap 127. And in Cap 127, there are three parts. The first part has to do with customary law marriages. So in the past, customary law, which was not registered and was not regulated by any statute, is now also regulated by Cap 127. So if you tell somebody that I've registered my marriage under Cap 127, you have not said anything because Cap 127 now covers customary marriage under Part 1. Part 2 is made up of Mohammedan marriage. Until about 20 years ago, it had its separate law. But now it has also been incorporated into Cap 127, the Marriages Act. And Part 3 deals with what we used to call the Ordinance Act. The Marriage Ordinance. Now, if you look at the Marriage Ordinance, Cap 127, we don't have anything like ordinance marriage. What we have there is called Christian. For those who, the lawyers, you may look at section from section 35 to 86. It is called Christian and Other Marriages. Christian and Other Marriages. So now, under Cap 127, we have all the laws in Ghana. So Cap 127 is no longer applicable to only the ordinance. We have the customary law marriage. We have the Mohammedan marriage. It's also covered by Act 127. And we have the ordinance marriage has now taken a new name called Christian marriage. Christian marriage. So now if we say you are your marriage is under 127. You married under cap 127. You have not said anything because cap 127 covers all the 3 marriages. In the past, it was applicable to only ordinance marriages. So we need to take note of that. Customary law marriages in the past knew no writing. So they were registered, they were not registered, and they were not recorded. But now, under the new Marriages Act, all the 3 marriages can be registered. So we should take note. Is there anything like an implied or constructive marriage in Ghana? When we talk about implied or constructive marriage, we are talking about a cohabitation between a man and a woman that falls short of the legal requirements of a marriage. There can be no implied or constructive marriage under the ordinance or under the Mohammedan marriage procedure due to their strict registration requirements. But in a paper presented in 2015 by the learned Justice Brobe at the 2015 bench conference, which was titled, "Who is a Spouse for Purposes of Inheritance?" The learned judge argued that only a marriage celebrated before witnesses in accordance with Section 31 of the Evidence Act of 1975 can be considered valid. Yes, and I have the law here. Section 31 of the Evidence Act, I'm reading. It says, a marriage which has been celebrated before witnesses is presumed to be valid. Subsection 3 says, this section applies both to monogamous and polygamous marriages. This section applies to both monogamous and polygamous marriage. So the learned judge submitted that for a marriage to be valid, there must be a ceremony where witnesses are present. The same view appears to have been shared by the Venerable Justice Ofori Boateng in his book, The Ghana Law of Evidence, at page 31 and page 32. However, the reality is that the courts continue to recognize customary law on various grounds, even where they fall short of the statutory requirements and the fact that there had not been any ceremony. Let's look at some of the customary marriages. Next slide. That have been recognized by the courts. For example, in Jabin versus Tego, the court expressed doubts about the consent of the 2 families. Earlier, I indicated that in customary marriages, the 2 families must give their consent. But in 1989-90, there was this case where the court held that, the consent of the 2 families are, after all, not necessary. Also, in the case of Inre Dixon, another 1991 Ghana law report, the court held that it is not part of Fanti custom for a Fanti man marrying a non-Fanti woman to go with his relatives or for the relatives to be present at the ceremony before the marriage will be valid. Again, where there is no formal drink provided to the girl's family, but the 2 have been living together for a number of time, the courts have from time to time recognized such relationship as marriage, notwithstanding the fact that no drink was provided to the woman's family. Also, where a man impregnates a woman and sends a drink to the woman's family to admit responsibility, and thereafter they cohabit for some time without the man proceeding to perform the marriage, the courts have held that such a relationship is still valid or a proper marriage under the law. There has also been an instance where the man did not pay any bride price, the dowry, but where an event happens in the other spouse's family, the person is being made to perform some customs. So no ceremony, but because the two parties have been cohabiting, in the eyes of the whole world, they are recognized as married. Next slide. Practical realities. Based on these developments, where customary marriage was inferred, even where no ceremony was held for the marriage to be valid in accordance with statutory provision under Section 31. Ofori Boateng, in his book, written in 2000, called for a clear judicial pronouncement on the matter, that the law says in the Evidence Act that there must be a ceremony where there will be witnesses. But it appears that some of the relationships that are recognized by the courts as marriages do not have any witness or any ceremony. So he asked that the courts should come out clear on this. In 2004, the Court of Appeal, through her ladyship, Akoto Banfo, Mrs. in one case, Mama Vesi versus Joanna de Graaf Johnson, decided thus, and I quote, that the inability to show that a ceremony had taken place will not be sufficient to invalidate a marriage if the consent of the parties to the marriage was proved by other means, and if it was also proved that the parties had lived together in the sight of the world as a man and wife. So the Court of Appeal felt the view, or had the view, that the mere fact that no ceremony did not take place did not mean that there had not been a proper marriage. In 2012, the Court of Appeal, through Appel J, in the case of Irene Goleku versus Justice Pobi, departed from the traditional requirements of the consent of the families, noting that what matters most is the agreement of the parties to live together as a husband and wife. So gradually, the courts have shifted from the strict position and are now recognizing various positions which in the past were not treated or deemed to be valid marriages. Next slide. For purposes of succession under PNDC Law 111, the courts have recognized persons whose name appear on obituary notices as widows or widowers, and proof of living together as spouses of the deceased. I've cited several authorities like Nana Ama Chumesi versus Brenya Akosua Chumesi, Cecilia Osafo-Adjei versus Hannah Aka Bla, Mrs. Juliana A.C. Duba, several authorities. So these days, if the family allows the widow or the other person to have his or her name on the obituary notice, it's likely to be deemed to be a proper marriage. Next slide. Effect of the law on customary and Mohammedan marriages. Under the two types of marriages, that is customary marriages and Mohammedan marriages, a girl eligible to marry will have to attain puberty. So under customary law, if a girl attains puberty, she qualifies to marry. The same thing applies to Mohammedan law. But under the Children's Act now, The law does not permit a person below 18 years to marry. So we should take note that statute has had effect on the traditional notion of marriage. The act also permits a child to refuse betrothal and marriage. In the past, if you are a child and your parents want you to marry, who are you to say you not permit? But now it is a right given to children under Section 14(1) of the Children's Act to refuse to enter into any marriage or betrothal. It is a misdemeanor to coerce a person to marry against his or her will. So it has now been made a criminal offense for anybody to be forced to enter into marriage. This is provided for under Section 109 of the Criminal Offences Act 1960. Also, where a female is made to marry under duress against her will, the marriage is of no effect. Section 100 of the Criminal Offences Act. Next slide. Registration of customary and Mohammedan marriages. Now, the law makes provision for customary marriages to be registered, as well as Mohammedan marriages. So we should take note. And for Mohammedan marriages, it is not only the marriage that has to be registered, but also divorce. If there's a divorce, it has to be registered. Failure to register a customary marriage is not fatal. In other words, if you are married customary and you decide not to register, it is not an offense. But under the Mohammedan law, it is compulsory. So if you marry at the mosque and you do not get it registered, that marriage becomes void. We should also bear in mind that non-registration under customary law is not an offense. But under the Mohammedan law, if you fail to get it registered, you commit an offense. You can be charged in court and convicted by the court. Registration of customary marriage may be done at any time. So if you married, let's say in 1980, and you now want to register your customary marriage, the law permits you. Section 2(2) of the Marriages Act. But in the case of Mohammedan marriage, the law says that after the ceremony, they have only 7 days, only 1 week. If they fail, so let's say Mohammedan marriage took place in the mosque. If it is not registered within 7 days, 1, the marriage is void, and 2, the 2 parties who married commit an offense, and they can be prosecuted, like I indicated. The next is that non-registration of a Mohammedan marriage in accordance with the law renders the entire marriage void. Section 27 of the law. So everything you did, if you fail to get the marriage registered, the whole marriage is void. What are the legal challenges associated with the registration of Mohammedan marriages? The question I'm asking is, isn't the law discriminatory and unconstitutional? Isn't it discriminatory against Muslims? Why is it that customary marriages, if it is not registered, no offense is committed? Why is it that if a customary marriage is not registered within even 1 month, 1 year, no offense is committed, and it can even be registered 10 years later? Isn't the law discriminatory against Muslims? 2, the illiteracy rate in Ghana, coupled with the majority's ignorance of the law, make it disturbing. How many people are aware of this law? And why should a Mohammedan marriage celebrated at a mosque and registered after just 10 days instead of 7 days, be deemed completely void. If divorce is not registered within a month, the law says that, so divorce must also be registered within a month. And if it is not registered within a month, the divorce is not valid. So if the law does not recognize the divorce, what is the implication? It does not change the fact that the marriage has ended. So all that the law seeks to gain with a strict requirement of registration of the divorce. It's not as if the divorce is not registered within the 1 month as stipulated, and the divorce is invalid, automatically the parties will come back. No. So why is the law being strict in such circumstances? We should note that where a Mohammedan marriage is not registered as required by law and ought to be registered void, it has sometimes been treated by the courts as customary marriages. So where the courts have sometimes adopted the practice that if the Mohammedan marriage is not registered, they overlook the strict legal requirements and treat the marriage as a customary marriage. See the case of Sadi Asalifu versus Alhaji Muntaru Sofo, 2018. Now we move on to part 2, love and property. Love and property. Next slide. Property distribution regimes. Under this, I would want to divide our property regimes into 3. What pertained in the past, before somewhere 2010, 2012, when the case of Mensah versus Mensah was decided. Before 2010 or thereabouts, the position of the law was that where 2 parties were married and there is divorce, before one could claim an interest or one could be entitled to the property, the person needed to establish or prove substantial contribution, like providing, let's say, receipts of cement purchase and all that. But in Mensah versus Mensah, the principle of equality is equity was introduced, where the court look at quantifying the services rendered by one party, for instance, the woman, in terms of washing the man's clothes, cooking for him, receiving his visitors, and other things, as a form of contribution. But it appears that in recent times, the law has changed slightly, where individual ownership is recognized, plus other considerations. Next slide. The question, this is, next slide. Is marriage an investment? Is marriage an investment? What is an investment? An investment is the act of putting money, effort, time into something to make profit or get an advantage, or the money, effort, time, etc. used to do this. So when you are doing something, you put money or something down with the expectation that you get profit. Basically, it is an investment. So when people are marrying, what is the determining factor? Do people marry because of love or because of future financial gains and profits? Do we enter into a relationship because of love or for gains and financial benefits? Just last week, I read, it's on Ghana Web, the executive director of Legal Assistance Network, lawyer Irene Abochi. She answered this question in the affirmative, that now marriage is an investment. So you can read from Ghana Web on Thursday, 30th April 2026. I chance on a lawyer who also said something is quite sarcastic, but permit me to read it. He said, go to divorce court. You won't see any woman asking for her love back. They are all asking for money and properties. Men are in love. Women are in business. Is it true? I would say this is quite unfair. Not all women, I would say, are in business. They are in love. Just today, I read about one prominent man in this country on Facebook, where he was commending the wife that for the past 35 years, his wife has been a blessing. So I may disagree. I would disagree that all women are in business and that women, it's only men who are in love. Does the court entirely agree that marriage is an investment? Next slide. So the Court of Appeal, in the case of Emmanuel Obeng versus Kate Nyameche, decided in Kumasi 2023. This was by Justice Ban J. He mentioned great men like Michael Jackson, Bob Marley, Bill Gates, Nelson Mandela, Kwame Nkrumah, Professor Brefa Buzia, among others, and argued that God had a reason for giving them special talents, gifts, and abilities. And it would be unfair to have these resources shared with their spouses simply because of marriage. This is what the learned judge said in part of the judgment. His Lordship noted, if God wanted to share the produce of their talents and innovation equally, he would have endowed everyone with the same talent, abilities, and capabilities. The idea that an individual loses his or her constitutionally ordained rights to own individual property merely for contracting a marriage invokes repugnant notion of marital communism, by which a man or a woman, through the device of a marriage, seizes half or reasonable portion of the spouse's property just by sitting on the fence and even probably undermining the other spouse and without showing contribution, without showing a contribution, would amount to marital slavery, where the slave spouse worked to create the wealth for the healthy and zero contributing spouse to share the fruits on an equal or almost equal basis. So this is what the Court of Appeal sitting in Kumasi said. Next slide. Court has accounted, next slide. Next slide. Okay. What has accounted for the changes in the law and the increased tension? Why do we have so much tension now? It is historical, but there are certain laws behind this. The first is, I will make reference to the 1992 Constitution. In the past, the law used to distinguish between husband and wife, but under the 1992 Constitution, the term spouse, which is a gender-neutral word, was adopted. So, in a way, the law recognizes both spouses as equal. The next is PNDC Law 111. Law 111 ensured, okay, I will jump this and explain later. We also have erosion of covenantal concept and enhancement of feminine rights. Now, let me go back to the history. I will start with customary law. In the past, the responsibility of the woman was to help the husband in his business or farming activity. So if a man married and had children, the woman and the children were to help the man. And it was the responsibility of the man to also maintain the wife and the children. Unfortunately, any property that the woman worked with the children for the man, if the man died under customary law, the woman was not a beneficiary. The property went straight to the family. So in a way, the woman was working for the man, and it was the responsibility of the man to maintain the woman. There's this concept also called coverture. Coverture means to cover. This is an European or common law concept, where upon marriage, that is if a woman married, she lost her identity. That's why the term Mrs. was adopted. The woman could not enter into any contract. The woman could not even have education. If the woman wanted to have education, it had to be approved by the husband. The woman could not do any work. If the woman wanted to work, the man must approve of it. And after approving of it, at the end of the month, the salary of the woman will be paid to the man. It was the responsibility of the man to take care of the woman. So any work that the woman did, the proceeds had to go to the man. So under the coverture concept, which was the common law position and customary law, the woman was not entitled to any property. All properties belong to the man, and the man's duty was to take care of the woman. Now, by virtue of the law, PNDC law 111 now says, no, if the man dies, it is now the nuclear family, the spouse and the children who must benefit, as against the family. Again, under the law, the man and the woman have been put at the same level. So the law has enhanced the rights of women, putting them at the same level. So the argument that the men make now is that in the past you were to come and help me so that I maintain you. So that if now the law permits you, we are at the same level, and when you work, you don't bring your salary to me for me to use some to maintain you. When you work, you pocket everything. Then why is it that I alone should maintain the house? So that is the argument the men are making, that in the past, I was taking that money to be able to maintain you. But now the law says, take your own money. So if you work and you take your own money, then it is reasonable to infer or to say that if you have gotten some rights, then you should be ready to bear the responsibilities. The 1992 Constitution is clear on this, that rights go with responsibilities. So the men are saying that if the woman status has been enhanced, then it must be accompanied by the requisite responsibility. So if you look at the Matrimonial Causes Act, for instance, Section 16 uses, which has to do with maintenance of the spouse. So the law now changes the maintenance responsibility, which was formerly entrusted to the man, to both parties, depending on who has the financial wherewithal. So the law now seeks to bring a balance by changing wife to spouse, so that either party could support the other. And this is clear in the Matrimonial Causes Act. What are the arguments canvassed by the woman? The woman said, yes, even though we have our rights enhanced, it does not mean that is the end. We continue to perform domestic chores such as cooking, washing clothes of the husband, taking care of the children, and keeping the pregnancy for 9 months. So if the men say we should be equal, then they should also come for the pregnancy. And childbearing, we still do all this. So what are you saying? And they also rely on the Lands Act. The Lands Act now says that even if you have your property and you want to alienate it, you need the written consent of the other spouse. But the Supreme Court in recent times have tried to give it the purposive interpretation that that property in the Land Act is being referred to matrimonial property. That is property jointly acquired by the two spouses and not one party's property. Next slide. The law, love and property. What the law thinks marriage is. The law thinks that marriage is contract with state interest. Yes, marriage, there must be offer acceptance. The other person's consent is necessary. Capacity is required. I indicated earlier on that capacity is the age you must attain to be able to marry. And in Ghana, it is fixed at 18. So all these are legal requirements that have been set by the state. Also, you don't have to love to marry legally. If you want to marry legally, you don't need love. You need the law. When the love dies, the next is status. Marriage changes one's status. Just by marrying, a spouse attains a status as wife or husband. And that comes with about 100,000 rights automatically. So marriage confers on the party status, which is accompanied by plenty rights. Also, marriage is a public institution. The state cares because marriage orders property. Marriage ensures that the children are protected. Marriage stabilizes society. In one case called Hyde versus Hyde, the court held that marriage is the foundation of society. And under our Constitution, Article 28, it says that the state has an interest in the family as a basic unit. And when we talk about family, we are talking about it through marriage that we get a family. However, the courts don't marry for people because they are in love. They allow people to marry because society needs order. So the law says that marriage is worth it. The law says that marriage is worth regulating. The law says that marriage is worth protecting. The law says that marriage is worth dissolving carefully. But what does it give you? What does it give you? Let's look at the next slide. Next slide. Legal benefits, judicial reality, and we find out whether it's worth it. So what are the legal benefits? The first is property rights. Yes, and for the judicial reality, it enables the spouse to be entitled to property. If you marry, the law allows you to be entitled to the property of the other person. So you say, yes, it is worth it if you are building wealth together. What about succession? That is one of the parties or spouses passes on. PNDC law 111 Under that law, spouse is a key beneficiary. Girlfriend gets nothing under PLDC law 111. If there is no will, there's no, if the deceased person did not make any will. So if excluded, and again, if a spouse is excluded in a will, the man or one spouse made a will and he excluded the other, the law permits the one who was excluded in the will to go to court to ask for a reasonable portion of the property. So you say yes, it is worth it if you want automatic protection. Again, in the area of children, what is the judicial reality? In some jurisdictions, if you are not even, but Ghana is different. If you are not married and married in wedlock, and you are born out of an illicit relationship, you are deemed to be illegitimate child. So those born in wedlock have clearer status. And this is, they are entitled to right to name and others. So you say yes, marriage is worth it if you are planning to have kids. The next is evidence privilege. In law, if you have a communication with your spouse and it goes to court, you can decide not to give evidence against your spouse. And the law gives you privilege, spousal privilege. No law can compel you to testify against your spouse in respect of communication you had. So when it comes to that, we say yes, marriage is worth it if you value privacy and loyalty. When it comes to death and medicals, when one party or the other spouse is dead or is hospitalized, the spouse gets some assets that the girlfriend will not get. The spouse may have access when the spouse, the sick spouse is in ICU. The spouse can claim for loss of consortium. So we say yes, for the sake of crisis, marriage is worth it. The law listens more to spouses. And the next is burden. Burden, when it comes to divorce, the stress, the cost, the time involved. Sometimes it can take between 2 to 5 years before the marriage will be dissolved. So the cost of unwinding is the price of legal protection. So in that case, you can say that marriage is not worth it. The law makes exit out of the relationship very hard because entry is easy and the consequences are serious. Gardner versus Gardner said that marriage is not a free market experiment. The burdens exist to protect the benefits. So legally, marriage is still worth it on paper, but people don't leave paper. People leave, people leave people. They don't leave the paper, they leave people. So what about the love? Next slide. What courts can do and what they cannot do. One, what the law can do for you. The law can protect the vulnerable. So if you are married, the law can protect you by virtue of the Domestic Violence Act. Court can step in when the love becomes harm. Also, the law can enforce promises, maintenance, and child support if the other spouse is not up to his responsibilities. The law can step in and enforce the promises. The third is the law provides structure for breakdown. Divorce isn't pro-divorce. It is pro-order. Divorce seeks to ensure order. better is legal divorce than abandonment. So we've seen what the law can do. Let's look at what the law cannot do for you. One, the law cannot create love. So if your spouse does not love you, you can't go to court to compel your spouse to love you. It's more emotional. Courts can dissolve marriages, but they cannot restore affection. Again, the court cannot enforce feelings. If the man says he has lost any feeling or affection for you, the court cannot enforce it. Breach of promise to love cannot give rise to action, but breach of promise to marry can do that. Again, the law cannot heal. The law does not have a balm to heal love. Judges divide property, not hearts. The gavel ends contract, not grief. So you may go to court for the court to end your marriage for you, but it cannot end your grief for you. Significantly, the law cannot chain love. There's this US case of Lavin versus Commonwealth of Virginia. As until 1969, 16 states in the United States of America had laws that were against interracial marriages. That is, you can't marry from another race. So there was this white man called Perry Lavin. He met an African American and had love for him, so they married. At the end of the day, they had to be sent to prison. And what the judge said was that the Virginia court's judge said that there was a reason why God placed the various, created different races, the black, the white, the red, the yellow, and there was a reason why he put them on different continents. So attempt by a white man to marry an African was deemed to be challenging the will of God. So that was the notion at the time. So they did their best to stop them. They went to prison, but eventually love prevailed. So the law cannot chain love. So if the law cannot give us love, why then do we marry? Let me say that now, I said earlier on that the courts have now moved away from 50-50, the notion of 50-50 share of property. Various factors are now taken into consideration when it comes to property distribution upon divorce. I will quickly, for the sake of our time, I will quickly take you through the factors. One has to do with ownership of the property. The court considers who owns the property. Is it only one person or the two parties own the property? To whether the construction started before the marriage or during its subsistence. Was it property that one party had before he married, or it was when they married that they began the construction? 3, sources of acquisition. Where did the money come from? Whether through pre-existing financial resources of one spouse. That is before the marriage. So one of the spouses had substantial amount which he used for the two parties to acquire the property. Or whether it was a loan, or whether the loan has been fully paid or is outstanding. The courts have held that where a loan was used to acquire the property, if at the time the marriage is dissolved, that loan had not been fully paid, then it cannot be deemed to be a matrimonial property, but will be deemed to be the property of only the party who contracted the loan. This is a J versus a J. Premarital assets, whether the properties were properties before the marriage was contracted. What are the financial contributions by each spouse towards acquisition or the improvement of the property? What are the mutual financial understanding, whether explicit or implicit, to maintain financial equality during marriage. For instance, the man says, I'm using my money to put up the property, whilst you use your money to maintain the house. So in this case, you see that there's that mutual understanding. The court still considers non-monetary contributions that are intangibles, such as domestic work, child rearing, emotional support, and moral guidance. Each spouse's earning capacity. So if it's a 90-story building and you go and say, oh, I put it up. Meanwhile, at the end of the month, you are paid 500 Ghana. It becomes obvious that you lied. So the court looks at each spouse's earning capacity. The length of the marriage. If the parties have lived in the marriage for, let's say, 30, 40, 20 years, as opposed to maybe a marriage that was contracted about 2-3 years back. The age and needs of each spouse, children, and who cares for them. These are the considerations that the court. What is the way forward? Next slide. There's a need to review some of our laws. For instance, Section 31 of the Evidence Act, which says that marriage must be witnessed. In practice, the courts, especially in most customary marriages, the courts do not apply this provision. And also the relevant provisions of Cap 127 pertaining to the registration of marriages under the Mohammedan ordinance or Mohammedan law. It is not fair. It must be reviewed to be in sync with the realities of the day. Doctrine of advancement must also be considered. For the sake of our time, I cannot go into details. Build together, document together. If the two parties are contributing, then there's the need that you get your name on the property, the title deeds of the property. You don't use Mr. and Mrs. Tomorrow the man may marry, and that Mrs. may be the new woman. So if you are a Fia Mansa, use Kofi Kwache and a Fia Mansa. So you build together, you document together. The nurses, I advise people to adopt prenuptial agreement when you are married. Ensure that all properties you are bringing into the marriage are written down for the sake of the future. And even in marriage, you put down all the property for the sake of the future. And also, you can make postnuptial agreements when the marriage is to be dissolved. Who gets hurt? Also, if you don't want problem, you can write a will. If your marriage is breaking, please. Divorce is expensive. So I advise you to choose mediation over war. It saves money, time, and the children. In conclusion, is it worth marrying? Legally, I would say yes, because no other contract gives you more than 1,000 rights by simply saying, yes, I do. Immediately you say, yes, I do. You get plenty rights. Cohabitation is a risk. Marriage is a legal regime. The Supreme Court calls it the most important contract. Socially, yes. Every time society devalues marriage, the courts get busier. Child support cases go up. Domestic violence cases go up. Estate litigation goes up. The law becomes the family. When the family breaks up, we pay more to clean up what marriage used to prevent. Even your pastor will say, yes, because God says he hates marriage. But you as a person, I would say it depends on you. The law gives a spouse, but not character. The law enforces contract, not commitment. Only commitment fulfills it. And my final word to you. So is marriage still worth it? I will say, go and ask the judge. He will tell you the law still thinks so. That is why marriage registry is open on every working day and the divorce courts are full. Go and ask the law. It will tell you marriage is worth it because children are worth it, property is worth it, and order is worth it. Ask the Bible. It will tell you that whoever finds a wife finds a good thing. But ask your heart, because the Lord gives you the license. Only love protected by vows and enforced by character makes it worth it. The governor can end the marriage, but it cannot start one. That is up to you. Thank you.
My Lord, thank you so much. This has been a very, very insightful session. At this point, we will take some questions. So if indeed you have a question and you want to give it viva voce, please just raise your hand and we'll unmute you. If you also have a question and you can't speak, kindly type. We read out the question. My Lord, I have a question to ask about the prenuptial agreements. How do you bypass Article 22 of the Constitution, which makes it mandatory for you to have some equitable sharing? I think that'll be my first question, my Lord. If you could assist me, thank you.
All right, thank you very much. You know, the law respects individual agreements unless I will repeat, unless the prenuptial agreement is totally unfair. If it is fair, the law respects it. It is not bypassing, but where the prenuptial agreement is intended to totally and completely prevent one party from benefiting, that one, I would say that the law would be suspicious about it. It's like a will. You must make a will and the law will respect it. But where the will is intended to take everything or deny your spouse from getting anything, then the law will step in. So it's not bypassing the Constitution. The law still respects individual arrangements. Only that the prenuptial agreement should be reasonable and fair. Even in advanced countries, it is not every prenuptial agreement that is forcible, where it must meet some minimum level of morality and fairness. If it does not meet that minimum threshold, then I'm sorry, the law may be suspicious about the agreement.
My Lord, thank you so much. So effectively, the prenup has to be aligned with the Constitution. All right. So there are
Exactly
a few. So there are a few hands up. Nashiru Kantin, please go ahead. Nashiru Kantin.
Good evening. Thank you, my Lord, for the presentation. My Lord, my concern is the balance between Article 22 and that of 18. Has the court not prioritized Article 22 against Article 18 with respect to the right of individuals to own and their own properties, even in marriage, based on case law that you have reviewed so far?
Yes, thank you very much. That was at a point. Emphasis was on Article 22, Mensa versus Mensa era, until recently. If you follow the recent decisions of the Supreme Court, like Sapon versus Sapon, like there are about 3 recent Supreme Court decisions that focus mainly on Article 18. Article 18. So, and they, in their discussion, they admitted that at a point, the law seemed to be gearing only in favor of Article 22. But now the law has taken serious recognition of Article 18, which allows individuals to own their own property. So I beg to differ that the law has prioritized Article 22 over Article 18.
Okay, I have shared the case. Abuna Pokua Yaokwache.
Thank you.
All right, most grateful. So the Esel Edu, please go ahead. Esel Edu Yabua.
Hello, good day, my Lord. This
Yes.
has been an insightful discussion. We thank you for this wonderful presentation. My question to you, my Lord, is there has been a public consensus, or I don't know, the best way maybe I may put it, that there are some places where there could be a secret divorce, where there could be a marriage, and a man or a woman can secretly go to that place and divorce the woman, whilst maybe a partner might not be aware. And when it comes to maybe the time, maybe both may decide to divorce together. Meanwhile, based on that case, maybe the person can use that as previously divorced already. I want to know your concerns. Is that also valid in Ghana? Maybe per that rules jurisdiction or jurisdictional provision of that state. Thank you.
So thank you very much. In fact, any secret divorce is invalid. Why is it done secretly? We need to know that when it comes to customary marriages, it has to be dissolved customary, and the families are usually involved. And when it comes to what we continue to call ordinance marriage, which is now called Christian marriages under the law, you have to go to court. It's only the court that can dissolve an ordinance marriage. So any marriage without the consent of the other person, any dissolution without the consent of the other spouse is void. And in Ghana, secret divorce is not allowed.
All right. Most grateful, my Lord. Eric, Reverend Ofori, Eric Rev Ofori, please proceed. Eric Rev Ofori. Okay, if he's not ready, Emmanuel Amwafo. Emmanuel Amwafo, please proceed. Emmanuel Amwafo.
Hello.
Yes.
Thank you very much. I'm very much grateful for the opportunity given me. Thank you, my Lord, for such a powerful presentation. So you made mention that formerly customary marriage were not registered, but now they are. And I want to find out whether during the registration, it is stated emphatically that the man can still marry more than one. And if it is so, what happens to the woman? Is that not gender bias? So that is my question. And if the answer is yes, it is stated that the man has that license to marry more than one, then what is the essence for the registration?
All right, thank you very much. Yes, customary law now permits the marriages contracted under them to be registered. But I did make the point that the registration is optional. It is not compulsory. In fact, prior to 1991, if you did not register your customary marriage and the man died intestate, that is without making a will, you were not entitled to benefit. But in 1991, thereabout, 92, thereabout, the court gave a decision and even a statute was enacted which made it possible for persons who did not register their marriages under customary law to benefit. So since that time, the law requiring mandatory registration of customary law has ceased to be in operation. Yes. Coming to the whether the right given to the man to marry being discriminatory, We need to interpret the law in the context, the law as an entirety. In other words, if you go to Article 11.1, it spells out the laws of Ghana. And the laws of Ghana include customary laws. And customary laws were those that were used by our forefathers before the white man came. So during our forefathers' time, the man could marry more than one. So it is not the Constitution which is, the Constitution respects these customary laws. So it's not the Constitution which is saying that men can marry, women cannot marry. The Constitution is only recognizing something which is already part there with the people, what the people already know. So customary law, like I said, it varies from locality to locality or community to community. So because the Constitution recognizes this customary law, and it is these customary practices which allow the man to marry, I will find it difficult to agree with you that the right of the man to marry in this context is unconstitutional, unless the Constitution comes out clearly to say that customary law marriages are no longer valid. But we want to move the law alongside our custom, alongside our cultural values, alongside our customary practices. So the law is only respecting what the people do. So I don't see it to be, yes, you may argue that it is discriminatory, but we need to balance it against the people's value and practices. Thank you.
All right, most grateful, my lord. Let's hear a female voice. Mabel Amajimfua. Mabel Amajimfua, you have the floor. Mabel.
Hello, sir.
Yes.
My lord, thank you very much for the opportunity given. My lord, please, good evening.
Good evening.
Thank you very much for the inspirational, this webinar is very inspirational. My lord, my question is, when I first married, my mind wasn't on property. So all we were doing were done in the name of the man. That's my husband. Knowing very well we will not divorce, because right from the beginning he told me we are not going to until death. But looking at the laws that are coming now, so all we were doing together, although everything was in his name. We were doing all together. Sometimes I take how do you call it? Receipts, sometimes not. But in this case, or in these days, while they are saying that when you are to divorce, you need to produce certificates to indicate that you contributed in the bringing up of the property. Here is the case, we did all together, but there were no receipts on my part. I sacrificed to stay behind in taking care of everything. While sometimes I added money or I bought so many things, but the chunk of the money was from the man. So supposing we are divorcing now, what will be my advantage? Or I just go because without nothing, because I may not get plenty certificate and receipts to defend myself. I don't know if my question is clear.
Yeah, very clear. My lord, you may proceed.
Yes, thank you. Question, Mabel. There's no law-based certificate, But we want, as much as possible, evidence. You don't just go and say that I played a role in the acquisition of the property. So any form of evidence, like if you have people who can come to court to testify, when you married, let's say about 20 years ago, 10 years ago, but the property was acquired about 6 years ago, and that time the amount you were taking, there are so many things to use as evidence. We don't only depend on paper. Yes, if you have the paper, it helps. But you can look at other factors that at the time you were working, at the time you were taking so much, and he was taking that amount. So all these factors are taken into consideration. So now we don't look at only one factor. We look at multiple of factors to decide what is due you. So if I'm not praying you get to that level, but if you should get to that level, the law will not say just go like that because at the time you did not keep your receipts or but as much as possible, you would have to convince the court that you supported. Thank you.
All right, I'm most grateful, my Lord. For the sake of time, let's try and summarize our questions. My Lord is a very, very busy man. So let's look at Mameya, another woman. Mameya. Mameya, please.
Thank you, Mr. Moderator. And my Lord, thank you very much for this opportunity. My question has to do with diaspora. We have a lot of women living outside Ghana, working with their husbands, like working so well, making good income. And the man will come home and take lead to try and do something. So just like my lady, the lady who just asked the question said, they will have these properties in their name. And the women trusting their men will not do much to add their names, because sometimes you are seen as, oh, you want me to die so that you take over the property. So most women sometimes get silent. But looking at issues on ground now, how will such a woman be treated just in case she ignored or she decided not to do much to add her name to these properties that she and the husband, have acquired? In such a situation, is this woman going to lose her hard-earned property, or is the law going to be looked into and ensure that this woman or this lady doesn't lose whatever she worked for? Thank you.
Thank you, Mamia. Your question is quite similar to the Mabel's question. And that's why maybe in the past you didn't know. Now you are being educated, so you know how to order your affairs. What has happened in the past, maybe like those days, if it was building and you did not take receipt, you cannot undo the past, or you can't get the receipt. But going forward, we all have to be watchful. It's unfortunate we have gotten to this point, but because of the realities of the day, in matrimonial setup, a marital relationship, you have to be watchful. That's why I said you can also look at nuptial agreement. Nuptial agreement is agreement that is made during the subsistence of the marriage. So if a particular property is being purchased and your money is involved, then it must be clear whose name will be on the property. So from now onwards, I believe that we will be able to do the needful. But when it comes to divorce, like I said, we don't only look at one factor. We look at multiple of factors. So the length of the marriage and all that, the age and the need, so many factors. So I would say that it will be difficult for the court to say go empty-handed when you put up a property. But where you have the evidence, it puts you on a certain pedestal, a certain advantage, as opposed to just going to court with no evidence. Thank you.
Most grateful, my lord. Nana Kojo Kisi, please keep your questions very brief. Nana Kojo Kisi, please proceed.
All right, thank you very much. I'm grateful, my lord, for the presentation. So my question is in relation to the exception of properties that will be classified as spousal property, particularly relying on the authority of a J and a J and Fin and Fin. And I believe same has been restated as one of the grounds under SAPON and SAPON in terms of the source of acquisition. In that, in a J, as you rightly stated, acquisition from loans which are still pending and not been settled will be excluded as part of the property. I think there's a bit of challenge in there. I believe the rendition rather should be that there should be distribution of such property, which will go with the assets in terms of the property as well as the outstanding amount to be paid, so that it will be shared in that proportion. So I want to find your mind on that, please. Thank you.
Nana Kwejo, thank you very much for your question. I will direct you to the where they sell the law books. You will find my book on land law. I have discussed this extensively. In fact, when the Supreme Court decided that the law came, I shared my opinion, and I felt, yes, I had some issues with the decision, but unfortunately, not my thinking here is the law. What the Supreme Court has said is the law, but I express an opinion, and I believe you're a lawyer. If you get a book, you would see the comprehensive discussion I did in respect of a J versus a J proposition. Thank you.
Thank you, my lord. Indeed, I also recommend the book. You may also look at the dissent in that particular decision. There's a very interesting dissenting opinion by the women of the court. All right, so Samuel Nyakon, we are running out of time. My lord, I don't know whether you can oblige us about 10 minutes. The questions
no problem.
Are overwhelming. Most grateful.
No problem.
Thank you, my lord. This Reverend Nyakon. Thank you for the holistic presentation. I want to know, as a pastor, can a member sue a pastor if that pastor is not recognizing that member's marriage? Because we don't have church marriage in the country, and a member goes to contract a marriage that is either customary or the ordinary, but he didn't come to the church for white wedding. Now I want to a member want to contest for election in the church, and they say, oh, because you did not perform your marriage in this way, you cannot. But the laws of the land recognize that a member's marriage. Can that member sue that pastor or the church? Thank you, my lord.
Thank you very much, Reverend Samuel Nyakon. Yes, if the church has, through the church misled the member, and as a result of that, the member's marriage is at jeopardy, obviously he can bring an action against the church for misleading the member that the place was. But the church too may put up the defense that the member too should have conducted due diligence, and that may reduce the damages. So you don't just go and say, I'm coming. You being so it's either way. Either way, the church has a responsibility to ensure that before they solemnize any marriage, the place is registered and it complies with the legal requirements. And the member too is your future, is your life. You also must ensure. I remember when I had to marry, but for many years, several weddings had taken place in my church. But I found out and realized they had not registered the building. more than 50 marriages have been weddings have been celebrated. So I didn't do my wedding there. And I drew the pastor's attention, and they started, they got the place registered. So you also have a responsibility to ensure that where you are marrying, the place is registered. Yes, the church can, you can get some damages, but your future, your marriage would have been in jeopardy. Thank you.
It was grateful, my Lord. Kwabena, please proceed. Kwabena, you have the floor. If he's not ready, Ohenewal O. Ohenewal O. Ohenewal, you have the floor, please. Ohenewal, we can't hear you. Okay, Benjamin Banahene. Benjamin Banahene, please unmute.
Okay, thank you very much. My Lord, my question is, in a situation where you register your customary marriage in the registry, at the registry, and you don't annul it, you've registered it and you've been in the marriage for over 30 years. You don't go to annul it, and you still go back and then do another customary marriage with another lady. And it happens that you now want to share your properties, where there has been a separation with the first wife, who you still haven't gone to the registry to annul the registration of that marriage. Does the first wife still has the chance of doing any claim in such a situation?
All right, thank you very much. Let me say that if you marry under customary law and get it registered under the law, it does not prevent, the registration does not prevent the husband from marrying another woman. The husband can marry 20 and get all of them registered. So the mere fact that your customary marriage was registered does not mean your husband is prohibited from marrying another person. And all the 5, 10, 20 that your husband will marry, they would all get equal share of the property. It's not only the first one. And in customary marriage, or with customary marriages, the husband need not annul the first one before he can register again. So you may want to know then what is the relevance of registering your marriage under customary law. It's for evidential purposes. Evidential purposes. Let's say 20 years time, 20, 30 years time, all the witnesses or the family members who were there died. And the other family members do not recognize you or have issue with you. So when it goes to court, when your husband dies, the family comes to say, no, he never performed the rites, or the deceased person was not married to the person. What will help you is the registration will speak for you. You will not need to call anybody to come and prove to the court that indeed you were married. So it is for evidential purposes. But apart from that, it does not have any influence or effect in the sharing of property. It does not have any effect in the on the right of the husband to remarry. It is only ordinance marriage. If you marry your, register your marriage under the ordinance, which is now called Christian marriage, and you go through the law, that one is purely monogamous. That is one man, one woman. But customary law, like I said, it is potentially polygamous. The registration of the customary marriage does not take the polygamous nature out of the way. In other words, if you register, it does not prevent the man from marrying again. Thank you.
And Lord, I'm most grateful. Now let's look at some of the questions in the chat box. So Richard says, I want to know in respect of property sharing, how are the factors considered by the court? Are the factors considered cumulatively or by each factor, especially where the property is in the name of the spouse who fully funded the property though largely in the subsistence of the marriage? That's Richard's question, please, my lord.
Okay. So now, the court starts with the assumption that the property is a marital property. That's the basis upon. If the property was acquired during the subsistence of the marriage, it is presumed that it's for the two parties. But if the other man brings, let's say, evidence that the property is registered in his name, then the law then proceeds to say that then it is not a marital property. It is for the person who provided the evidence. Now, the burden shifts to the other person who is making a claim that the property is the matrimonial property to come and testify to justify that the property was acquired by the two of them. So we start from certain premise. When you come to court, we take it that the property is for the two of you. Then one person pulls a document to say it's for me. You say, okay, once it's for you, then it's for you alone. Now the other person then will have to come and demonstrate that the property is not for you alone. He also played a role in its acquisition. And so that is where the other factors like how he supported, the number of years, and those things would come in. So we start on a certain premise and we take it one after the other, depending on where the parties are coming from.
That's great for my lord. The next question says, what about 2-year absence without any sex or contact? Is that marriage still valid? That's the question from Lenovo.
Yes. Yes, in fact, under the law, it is only 7 years that if you are not heard of. After diligent, even that one, the law says after diligent search. You don't sit here without asking around and after diligence, and that the law would presume that the other person is dead. But when it comes to ordinance marriage, there are grounds for which you can come under. One of the grounds is where you can come and say that the parties have not lived in the eyes of the world as husband and wife for 5 years. When it comes to 2 years, 2-year desertion, the law says that it must be with the consent of both parties, that they would want the marriage to be dissolved. But without the other person's consent, then the law fixes 5 years.
All right, most grateful, my lord. Samuel is asking, can someone pursue a divorce case at the court, although the marriage was contracted as customary?
Yes, under Section 41 of the Matrimonial Causes Act. Generally, the marriage is to be dissolved at home without going to court. But the law permits the courts to come in certain exceptional circumstances. But that one, you need, the law says may apply. So you need to apply to the court before the court can give you leave. And usually, it is in respect of the reliefs, the claims, that when the marriage was dissolved at home, they did not give you a reasonable share of the property. Or you have children, but the family wanted to give custody to the other spouse, and you think it is not right. So where you want release under the law, in addition to in addition to the petition, then you can apply for the court to step in, even when the marriage was a customary marriage.
All right, most grateful, my Lord. Because of time, let's take one more Viva Voce question. Kojo Datsi. Kojo Datsi.
Okay. My Lord.
Yes, Kojo,
Good evening,
please.
my Lord. Thank you very
Yeah,
much
yeah.
for this opportunity.
Good evening,
There's a case, there's a pending case I'm confronted with. The husband was outside the jurisdiction.
because it's a live case, I would plead that I'm not comfortable because it's a live case, and who knows if it appears before me. So please excuse me on this.
My Lord. Okay, that is fine, my Lord.
Thank you for respecting my view.
Most grateful, my Lord. It's very possible that the appeal could go before him. All right, Harold, since Kojo's question could not be asked, Harold, please ask the last question. Harold.
Thank you very much. Thank you so much. I'm grateful. Thank you, my Lord. My question has to do with divorce cases that have proceeded in court, and the judgment of the judge was not based on any of the grounds on which the one of the litigants or brought the case, but rather on the fact of deception. I don't know if deception is one of the grounds on which a court can grant divorce to the spouse who is seeking the divorce. And in that case, what happens to the cost of the legal fees? Is it the one, for example, the spouse vacated the matrimonial home or deserted the matrimonial home without the consent of the other spouse, and now later he or she went to court to seek divorce, and after proceedings, it was decided by the judge that the deserting spouse rather went into the marriage for purposes like having children because of her age, and then leaving the marriage so that she can use the children to extort or demand, constant monetary support from the man, and then the marriage is now dissolved. Who gets the cost of legal fees?
All right, Harold,
Thank
before
you.
you go, let me find out. You said the judge relied on deception or deception.
Deception. If the judge found out that the spouse seeking divorce was doing so because she's obtained what she went into the marriage for. Like, excuse me to say, we have women today in their early 40s or late 30s who are no more interested in marriage, but they want to have children, and they don't want to have children outside marriage. They just want to marry, have children, and then divorce the man so that they will use the children to be, I will not use the word extorting, but they will use the children to be receiving money legally from the court, from court judgment, to support the children. And then they will no more be responsible for any marital roles. So they got children in a marriage, leave the marriage, and now use the children to extort money from the husband they have divorced. And after those proceedings, who pays the cost? The husband has spent money going to court and up and down. But if the husband wants cost of legal fees, who pays those costs? To whom will those
All
costs
right,
be
thank you
awarded?
very much. Thank you very much. The first point having to do with the ground that the court relied on as deception. Yes, if you look at the grounds for dissolving a marriage, it's one ground. That is where the marriage has broken down beyond reconciliation. And several factors are taken into consideration in arriving at that. And one of them is unreasonable behavior. So if the court found that one party consistently deceived the other person, the court could rely on it as a basis to terminate or dissolve the marriage. And as to the cost, normally, let me say that it is not the party who deserted or who is at fault, who is made liable. The court looks at the entire facts. Sometimes some people think that because if they leave the marriage, especially some of the women, if they leave the marriage, the man may be treating her badly, but they think if she leaves the marriage, she will not get anything. No, it does not work like that. When it comes to property distribution, it's entirely different from who is at fault. So the two are different. And on the issue of cost, the court will have to look at both sides. Who is working? Who is in a better position to pay the other? So the court looks at all that. So you don't say because she left. When I was a lawyer, there was this woman who said for 7 years, the husband had not had an affair with her, and the husband could bring ladies when she was at home, have an affair with them for 7 good years. And in law, there's something called constructive divorce. So when she came, I said, Mommy, you think you are married? Your marriage collapsed 7 years ago. Though no court had declared it so, in the eyes of the law, the marriage has collapsed. So it is not because the woman has left. Maybe the court look at what made the woman to leave. What were the causes? What were the factors? We look at all that before arriving at who pays or who should pay what. So it is not automatic that anytime a case goes to court, it is the one who has left or the one who has done this who has to pay for the cost. The court will look at the entire circumstance and consider who has to pay the cost.
All right. My Lord, thank you so much. Because of time, we can't handle, we are receiving a plethora of questions. And quite frankly, we can't handle all of them. I will plead with my Lord to have another session with us. Hopefully, in that session, we can take more questions. But until then, thank you so much, my Lord. God bless you for your time, and may He replenish all that you've lost. For the participants, thank you so much for joining us. Indeed, if my Lord has a phone number, he can share for the books, those who may be interested in the books. I have my 2 copies here with me. They are very, very useful books. So if indeed you want them, my Lord, if you have a phone number, you could share so that I can put it out there for people who are interested, the lawyers particularly who are interested to buy the books. Thank you all so much for joining. We will have another session, definitely, and we'll take all of the questions. My Lord, the phone number.
Yeah, I cannot give my phone number out, but I'm giving the one who is in charge of the books, the number of the one in charge of the books, and if they contact them, it's 054 399 2718.
054 399 2718. 05 2718. Okay. All right. Hello, thank you so much. I have shared the number to Prince. Wonderful. So those of you who are interested, indeed, these are books I will highly recommend for any practitioner. So if there is nothing else, thank you all so much and do have a fantastic evening.
Thank you.